has everyone got a cup of tea? Or coffee, or whatever the hot beverage of choice is, because that's clearly the most important factor. I have a big cup of tea, which I've already demolished, and I'm accompanied by
Likewise.
all of the friends of Winnie the Pooh.
Right. Well, we're not quite at 7. We're at 63. So I make it 1 minute past 4. We've got quite a lot to get through, so I'm going to make a start, if that's all right. If I could introduce myself for those who don't know who I am. My name's Paul Lakin. I'm a barrister at King's Chambers, which that bit you've probably guessed at least. I'm, along with my good friend Eleanor Darcy, we are part of the property group at King's. And today we're hoping to do, I think it was being marketed as a fireside chat. Now, hopefully the chat part we can do. As you can see from my background, I think both of us are lacking in fireside. So we'll just have to leave that bit to your imagination.
I feel like we're bringing the fire though, so that's okay. I feel like, we will bring that as part of our discussion and delivery and chats today. So it's a metaphorical fire more than a literal one.
It's a fire within, I think, is where we are.
As you wish.
It's the burning passion for property law. That's that's what it is. So today what we're going to plan to look at is trusts of land and Talata claims. We're going to have a look at generally, this today is by and large unscripted. So again, apologies for any odd ramblings and moments of disaster, but that may or may not happen as we go along. We've got a rough agenda as to the topics we sort of want to touch upon. And those are, I'm going to sort of start off looking at classic sort of Stack and Dowd and what it means, what it says, and Jones and Cannot, and what it doesn't say. We then want to bring that on to looking at current cases to see where we're up to. In particular, the distinction that is being drawn between domestic and non-domestic, because of course in this sort of COVID world where you have relationships failing, so Talata's still fairly current, and B, you have businesses failing, and you have lots of, I did a trial just last week about the co-ownership of a pub, which immediately raises the question when it's a property that with a flat and living accommodation where people live and a business underneath, does this fall strictly under Stack and Dowden family ownership, or does this fall into the commercial context, and are there different criterias?
Can I interject just before you jump into those points? Can I just start for one point before you begin? People may wonder why we chose this topic and why deal with trusts of land in the present climate. And certainly there's been a trend that I've seen from probably the latter part of the end of last year, right through the early part of this year. There have been a number of instructions that have come across to me. Paul will echo this as well, in respect of claims relating to trusts of land. So cohabitees who've split up, people who are concerned about potentially maybe going bankrupt when financial support is withdrawn. So it seemed to me, and it seemed to Paul as well, that this was going to be a very topical subject that would probably cross all of our desks in the coming months. Now, none of us want for there to be relationship breakups. None of us want for there to be issues about bankruptcy. But I think given how difficult last year was for everyone, it seems fairly inevitable to my mind that there will be these issues. And I've certainly seen them. I think we will see more of them as the year progresses. And so we chose this topic because it's likely to be something that we'll all have to deal with at some stage this year, I suspect. And the law is always worth updating ourselves as to the case law, what the legal arguments are and where we are in the current legal framework, really.
It's also, I entirely agree with Eleanor, but also given the pandemic and the current ongoing restrictions, certainly in terms of evictions for property generally, I think both of us are seeing some impact on relief that's granted, and that's an area that we want to deal with. Hopefully we'll have time. As I say, we've got quite a lot, and it's quite a nebulous area that we want to cover. So the pandemic is having a real impact on the relief that the courts are minded to grant and the kind of orders that they're making, even if you get over all the substantive hurdles in order to succeed in your claim. So it is a relevant area. It is an ongoing area. It still causes problems because, despite of all the hopes of various courts, not always is box 10. Box 10 is on the TR1 is the box that contains the express declaration. Frequently that isn't ticked. So you're left with a classic Stack and Dowden case, or it is, and the parties want to argue that it doesn't reflect the position. So we want to start off by going right back to the beginning and have just touch base on what Stack and Dowden does say, what it doesn't say, and what it doesn't cover, and really how you need to think about things to progress your case. So let me just deal with that point quickly. I do want to mention slightly going further back in time, which is Lord Bridges' classic statement in Lloyds Bank and Rossett, because I think that formulation, and bearing in mind that formulation, helps put Stack and Dowden in context and Jones and Connaught, and also helps you consider the framework of you actually need to draw a flow diagram of decisions that need to be made.
And also for anyone who does insolvency work, the case of Pillmore and Mere that we'll come on to talk about, or I'll touch upon later, 2019 decision of His Honour Judge Kramer sitting up in Newcastle. He very much forms the view that in sole ownership cases where someone is seeking to rebut the presumption of equity following the law, that Lloyds Bank and Rossett, or Rossett, or however you want to pronounce it, still holds good. So it is relevant in that context as well.
Yeah, because what Lloyds Bank was a remarkably straightforward, which is one of the big problems when Stack and Dowden came along. Lloyds Bank said basically common intention constructive trusts are based on precisely what it says on the tin, the common intention, and that's what the parties need to demonstrate. It also is based, so far as you can, if you can, on express agreements and understandings reached by the parties. And Lord Bridge famously said, however poorly remembered. So phrases like, this is ours, this is our shared home, any kind of expression of unity that the parties could demonstrate to say it was an agreed attention that this was jointly property for the benefit of a family home. So you've got the agreement part, but then what he said is, if you haven't got an express agreement, what he said is he thought that only payments to the mortgage or would suffice where you have a lack of an express agreement.
Or a direct contribution to the purchase price.
Yeah, or direct, and that's where Stack and Dowden filled in the gap and moved away somewhat from that analysis. So Stack and Dowden, it has to be remembered, was a case where it was a joint ownership case where there was no express declaration of trust. That's a key thing to remember. And the basic points that the court determined were basically, firstly, that equity follows the law. So in those cases, the presumption is that in equity, it'll be held as joint tenants in the same as joint tenants at law. And then the burden of proof falls upon whoever is saying it should be otherwise. And then the court has to work out, and this is really falls into the second analysis of the Lloyds Bank test, work out what those intentions were from the whole course of conduct between the parties. And the court gave a whole list of things that it said could be taken into account, which is such as advice and discussions, any reasons why the house was purchased jointly, purpose the house was acquired, the nature of the relationship, the length of the relationship, whether there was any children, who financed it, what they did subsequently, whether there was any major refurbish work, who contributed to those. So all the kind of things that people were very used to dealing with were dealt with. The difficulty that partly Stack and caused was the analysis by Baroness Hale in terms of the whole course of conduct going on between the parties and quite what it was, whether the court was inferring or imputing or what they were doing at any particular time. And so luckily the Supreme Court came along not long after in Jones and Connaught, and in a joint decision by Lord Walker and Baroness Hale, clarified our mere mortals' misunderstanding of what their lordships have been saying in Stack. And Jones and Connaught really just builds on Stack and clarifies certain elements. So it says, again, the starting point is where you have, again, I should make it clear as well that Jones and Connaught was also a joint ownership case.
Mm.
So again, the starting point is where they're in joint names, the presumption will be it's joint tenancy and equity as well. And again, that presumption can be displaced where there's evidence of a common intention either at the time or subsequent. And that common intention can be adduced objectively from the parties. So the first thing you need to establish is, firstly, if you're going to seek to vary the declaration or the presumption, should I say, is that there was an intention that the property would be held in different shares or a different ownership to jointly. And that can be done either expressly or impliedly. If you get over that hurdle, you then have to quantify the share, which is back to the old Oxley and Hiscock case, which is just the dealings, what the court considers fair, considering the whole course of dealing. And again, the courts can imply or impute at that point what they consider to be fair between the parties as to what the agreement would have been had they made one. Again, if you have an express agreement to the first limb as to what how the ownership should be held and as to how that should be quantified, then you don't get into any of the realms of imputing or implying or inferring at all, because you've got what the parties actually say. And so that's where, and it also, and Jones set out how you go about dealing with the old situation, which is where you just tended to have one party on the title. And again, it was said that the assumption is, again, equity will follow the law. It will be solely owned both in law and equity. And unless you are wanting to establish that, you basically go through the same process. So you need to establish an agreement that it will be held on different terms, or you need to, by a course of conduct, show that that was the intention of the parties. And again, you go through that process and then the quantification process.
So the party there seeking to rebut the presumption has to make all the running. They have to rebut the presumption of equity following the law. So if there's a sole ownership case and say a wife tries to say that she should have a 50% beneficial interest in the property, which might be in the sole name of the husband or the former husband or whatever, there would be some argument, wouldn't there, of cohabitee, there'd be some argument about trying to rebut that presumption and how that would be done, and by reference back, I suppose, to Lloyds Bank and Rossett. What's this thing about the domestic consumer context? Where has that come from? And we'll probably touch upon it in the case law that follows, but how is that to be applied? Was there any guidance about that, really?
In Stack, this stems from specifically what Baroness Hale said in Stack and Dowden. Stack and Dowden said this is the presumption that equity follows the law was in the domestic context. So there's always been an issue as to quite what the scope of that is. And then you've got cases like Laxar and Laxar, where the Lord Neuberger has applied essentially a resulting trust analysis on the basis that that's a business context. So you don't need to consider Stack and Dowden, or that's often how Laxar and Laxar was presented. If you actually read it carefully, it doesn't say that. And there is a fairly recent Privy Council decision called Marr and Colley, which I do want to spend a little bit of time on later, that explains where we're up to in that. But there is still, and it's one of the areas of uncertainty in this, is to what categorizes, how you categorize the purely commercial, and the courts will treat commercial nowadays, or they will, the assumption is that there isn't the intention to have joint ownership in equity. Basically, that the assumption is that survivorship takes no place in the world of commerce, that people put money in and they expect their share. So therefore, the assumption is that there will be tenants in common. And if Lord Newburger's right, it will be on the basis of how much money they put in on the resulting trust analysis. That's the way, and that goes back to partnership law as well. The partnerships are always presumed to be in tenants in common, often in relation to the share of their partnership assets.
So that's your classic resulting trust, isn't it? Which I think in this domestic consumer context, whatever that actually means, but in that domestic consumer context, Stack and Dowden made clear, didn't it, that the resulting trust was dead in the water. You were not looking at that type of arrangement.
Well, this is one of the problems with Stack and Dowden. Baroness Hale said that, but then Lord Newburger said, actually, I prefer the resulting trust analysis. So one of the confusions that arose out of Stack and Dowden was basically whose judgment do you follow, and is resulting trusts dead in a domestic consumer context? One of the things that Jones and Connaught clarified is in the purely domestic realm, resulting trusts shouldn't play any part, because unequal contribution, what was clearly said was unequal contributions to the purchase price alone isn't sufficient to rebut the inference. So you can't simply rely on, oh, well, I paid more for the purchase of the house, therefore it shouldn't be divided equally, or survivorship shouldn't take place because I've contributed to it. That alone isn't sufficient to rebut. So in a domestic sphere, that is where we are. But as per my trial the other week, where you have a pub, which consists of clearly a domestic arrangement and a business bolted onto the bottom, does that fall into domestic sphere to apply Stack and Dowden, or should you apply a resulting trust analysis, or should you apply some other kind of approach, just say tenants in common if it's a joint held? And we'll come on to what my view is, and I think whether Eleanor agrees with that, we'll see. So that's kind of, I've taken long enough to cover ground that most people are probably fairly familiar with. So I want to hand over to Eleanor just to start going through some of the more up-to-date cases, so we can look at how things are progressing.
Can I just, before I ask you to move the slides, can we just touch upon box 10 and Goodman and Gallant, because it's often a question that cases that I get instructed upon, where there is a box 10 with an express declaration of trust ticked on your TR1. So the parties have ticked that they hold as joint tenants, or that they hold in tenants in common, or whatever. And quite often people will instruct me and say, are we bound by this express declaration of trust? Well, Goodman and Gallant makes it clear that where there is an express declaration of trust, it is conclusive evidence as to how the property is going to be held, subject to the TR1 being set aside on grounds of mistake, fraud, any of those type of factors. Now,
the usual vitilating circumstances.
Yeah, absolutely. Now, there is some suggestion in the practitioner texts and also in the authorities as I read them, that actually there could still be an operative proprietary estoppel, or there could be an express common intention constructive trust entered into subsequently to the TR1 being executed that might give rise to the shares being held in different categorizations aside from how the TR1 was completed with the express declaration of trust, that subsequently, because of this sort of ambulatory constructive trust type theory, I'll put it no higher than that subsequently the parties could have agreed to hold the shares differently in the property, out with what the TR1 says. It's there, I think it's runnable. The problem, I suppose, will be trying to prove it in the usual way and trying to convince the court that effectively there was this agreement, which is subsequent to the execution of the TR1. But certainly my view at present, and I think it's endorsed by Paul, is that courts normally look at TR1, Goodman and Gallant's conclusive evidence. If you want to then try and challenge it on one of those grounds, vitiating factors or some sort of subsequent agreement, or some sort of subsequent intention, it's probably going to prove quite difficult to demonstrate that to the court, I suspect.
Yeah, I mean, the classic theory of trusts is that a trust was declared at the point of purchase, and that was the same for common intention constructive trust or resulting trust. Clearly, a resulting trust can only work at the point of purchase because it arises out of the purchase money contributed towards a property. And the classic view of trusts was that common intention constructive trusts worked in the same way. What Stack and Dowden and Jones and Connaught gave force to was the fact that you could start off with one common intention, but that could be ambulatory, and over the period that could change. So people's intentions can vary with time, and what the courts have acknowledged is that the trusts can vary. And again, this is one of the areas that is quite unclear as to how clear and separate agreement you need to demonstrate that the trust has moved from whatever it started to a different point. But it's entirely right that an express trust was always thought of, that was it, cut off, bang, unless it had been varied by another deed of variation or a memo of trust that complied with section 53 of the Law of Property Act. It just simply didn't get off the ground, and you couldn't argue Stack and Dowden or anything. Baroness Hale kind of let the cat get out of the bag by saying, in Stack and Dowden, Goodman and Gallant was expressly agreed with, save that she said, unless it was varied by agreement, but never specified what that was. And then you get into the whole subcontext of, well, does that, most practitioners again take that to mean expressly an express agreement, again complying with either in writing by deed or complying with section 53. But it raises the argument that you could infer, possibly, I raise it no more as to whether it would work, that the court should take into account the course of conduct of all the parties to say that the situation had changed and there's a change of circumstances, so the court should imply a change of the trust. That's only been running, I think, one reported case, which was Clark and Midas, which is 2010 EWHC 3117. But that was just a strikeout application, and the judge held that Goodman and Gallant and Stack and Dowden didn't cut out that possibility. As far as I'm aware, there isn't a reported case where that kind of argument has been successful. So in terms, for the benefit of advising clients, you either have, if you have an express declaration, then unless it can be set aside for one of the usual reasons, that's really what you're stuck with. Or you are going to be in the realms of making new case law, and we can all go off to the Supreme Court and see if anybody agrees with us or disagrees with us.
Maybe that's an argument for the future, for a future date or a future seminar. We'll see.
For what it's worth, I think the classic theory of trusts would apply in those circumstances, unless you could demonstrate an agreement that complied with section 53. You're not going to get anywhere, but we'll see. The law may shift in that direction.
Well, thank you, Paul. That's been extremely informative and has helped us all, I suspect, to orientate ourselves as to where we are at currently, post Stack and Dowden and post Jones and Connaught. I want to talk to us about some recent cases that have engaged with the concept of Stack and Dowden and Jones and Connaught and where we're at currently, really. Thank you, Paul, for moving the slide. Paul is in control of the slides because I tried to share my screen and it didn't work. And for anyone who instructs me, they'll know how lacking in technology I am. So I tried, but Paul is the man with the screen. So he's going to move us on. So just forgive me for when I say that we need next slide or whatever. That's because I don't have the control.
I'm the clicker.
You are.
I'm like the next slide, please.
And I'm grateful for that. So thank you. I've, first of all, try to engage with this concept of the domestic consumer context. Is there any case law that will help us understand where we're at currently as to what is meant by that domestic consumer context? And there's a recent authority of Rowland and Blades, and I've set out there the citation 2021 EWHC 426 Chancery. By the way, these slides will be available afterwards, so there's no need to take a copious note.
From all good bookshops, I think they say.
Indeed. Next slide, please.
Oh, sorry.
So let's have a look briefly at some of the facts of this case. Parties were unmarried and in a relationship. They each had their own separate home. They spent time together at the respective properties, but never pooled their respective, go back, never pooled their respective resources. This is him
going the wrong way.
Trying to see if I have prepared my notes appropriately. All entirely unscripted, by the way, so I'll be telling him off after. Anyway, never pooled their respective resources and never had a joint bank account. And of course, some of the questions that you ask when a client comes in is, to what extent have you pooled your resources? To what extent are you putting everything into the mixer, as it were? So are you jointly owning your properties? Are you sharing your cash? Are you sharing your income and the bank accounts held jointly? All of those types of questions. Okay, so we didn't have that on the facts of this case. They purchased as joint tenants, albeit without an express declaration of trust, but there'd been some correspondence beforehand that had indicated that the property was intended to be owned as joint tenants, and they'd circled a box that said that they wanted to own in that capacity a property which they wanted to live in as a holiday home and weekend retreat. The claimant in the case provided the entirety of the purchase price. The defendant didn't provide a penny, and there was no mortgage, no financial contribution from the defendant to the acquisition of the property. Okay. Next slide, please. In respect of this type of context, it wasn't the normal domestic type context. And by that, I mean, what we've seen in Stack and Dowd and what we've seen in Connaught and Jones is, a couple effectively buying a property as a matrimonial home. That's a generalization, but that's normally the type of scenarios. This wasn't that type of scenario. They had their own properties. They were buying this weekend retreat, somewhere that they could go and enjoy. And despite that, the court took the view and applied that this was a scenario that was a much better fit for the common intention constructive trust, with the presumption effectively needing to be rebutted as to joint ownership, rather than some sort of resulting trust type argument, which would have obviously favored the claimant, given that he provided the entirety of the purchase price. So the court found that there had been no evidence that rebutted the presumption and no express agreement to displace that, so such that the property was held as it's by them pursuant to the terms of a beneficial joint tenancy. That case tells us, well, even if you're not buying a property for the purposes of occupying as a matrimonial home, the fact is that in that context, the court took the view that this fell much more squarely within the common intention constructive trust rather than a resulting trust.
Can I just hop in at that point? It's just worth saying that when you read the report, it's clear that neither party was actually arguing or had really addressed their mind as to whether this was a quasi-matrimonial home. Both skeleton arguments, it's clear, were arguing the case on Stack and Dowd and Jones and Connaught. And it was actually the judge that raised the issue as to, well, is that right? Can I really take this as, is this the situation that I should be dealing with? So the conclusion that he came to, that he did apply Stack and Dowd, was because both, and one party was represented by a silk, I forget who it was, because neither of them were advancing a claim that it was anything other. He didn't have that dispute to resolve, so he just applied Stack and Dowd. And so that does slightly water down the conclusions of this case, in my view.
They conceded, didn't they, on both sides, that was the applicable law. I suspect had either Paul or myself been instructed, we might well have thought, well, actually, there's a bit more of a fight to be had here about the applicable principles, particularly, as I say, in respect to the claimant and contributions, the money that had been paid across by the claimant. But be that as it may, even in the context of a joint purchase of a property that the parties are not occupying as their main home, this was the view that the court took in Rowland and Blades. Next slide, please, Paul.
Just before we do, can I just go off on a slight, I said, I think now is probably as good a time as any, just to go over Lascar and Lascar quickly, and then the case of Marr and Colley, just because it puts some context in the opposing views that we've talked about. Lascar and Lascar, of course, was a purchase of a home. So again, you'd immediately think this is a family context, by mother and daughter. Mother had lived there for a long time. It was a council house, and she was buying it with a substantial discount from the right to buy legislation. Problem is, she couldn't afford the house, she couldn't afford the purchase, so she wrote to daughter in, and it was bought basically as an investment. the evidence was that neither of them really intended to live there, and it was just going to be an investment. As I say, it was heard in the Court of Appeal by Lord Neuberger, who gave the decision, and he had no difficulty in saying, well, it was clearly just an investment. Even if I applied, as I say, even if I applied the Stack and Dowden, then I think that's been rebutted, because if on one analysis the mother hadn't contributed anything, everything had been paid for by the daughter. So what they did is say, well, actually the right to buy discount counts as a purchase, her purchase, or an element of the purchase price. So I'll apply a resulting trust, and that way mother got a substantial chunk of the property because of the discount. So again, like all cases, it's based upon the particular facts of it. But as I say, Lascar was held up as the view that Stack and Dowden did not apply in a commercial context, whatever that was. And even where you have, and it was held, even where you have a purchase by mother and daughter, that didn't make it a, or necessarily prevent it from being a commercial property, or sorry, a commercial purchase. Now, in 2018, or I think it was actually, it was May 2017, Marr and Colley came before the Privy Council. And again, it's worth note that it was a fairly heavyweight bunch of Privy Councillors, because it consisted of Lord Neuberger, Baroness Hale, Lord Kerr, Lord Wilson and Lord Sumption. So generally a bunch that have touched on this area a few times. And their conclusion, and I do want to read this out in full because it's worth, again, it's worth noting. And again, I should have perhaps, yeah, because what this is at paragraph 49, it says, the board does not consider, therefore, that Lascar's case is authority for the proposition that the principle in Stack and Dowden that a conveyance into joint names indicates legal and beneficial joint tenancy unless contrary proved applies only in the domestic consumer context. Where a property is bought in the joint names of a cohabiting couple, even if it is as an investment, it does not follow inexorably that the resulting trust solution must provide the inevitable answer as to how the beneficial ownership is to be determined. Lord Neuberger did not intend to draw a strict line of demarcation between, on the one hand, the purchase of a family home, and on the other, the acquisition of a so-called investment property in whatever circumstances that took place. It is entirely conceivable that partners in a relationship would buy an investment property which is conveyed into their joint names with the intention that the joint beneficial ownership should be shared equally between them, even though they contributed in different shares to the purchase. Where there is evidence to support such a conclusion, it would be both illogical and wrong to impose a resulting trust solution on the subsequent distribution of the property. And that's important to remember, as I say, that Lord Neuberger, who made the decision in Lascar, was part of the panel, part of the board. So then at paragraph 53, they say, if what Baroness Hale described as a starting point, that joint legal ownership would signify joint beneficial ownership, is to be regarded as a presumption, is there a conflict with the presumption of a resulting trust where the parties have contributed unequally to the purchased property in their joint names? A simplistic answer to that question might be that if the property is purchased in joint names by parties in a domestic relationship, the presumption of joint beneficial ownership applies, but if bought in a wholly undomestic situation, it does not. In the latter case, it might be said that the resulting trust presumption obtains. So what Marr and Colley, although it's only persuasive, of course it's not, and certainly that last bit is clearly obiter, suggests that if it's any kind of domestic context, even if it's for an investment, then you should start from the Stack and Dowden starting position. And it's only if it's basically an arm's length transaction between unrelated people that you then get into the proper business analysis that uses the resulting trust analysis. So I think that's where we are. But again, quite where the boundaries of that are is still to be determined.
Yeah, and there are a couple of cases now, hopefully next slide, which make clear some points in that regard, really, about where we're at in the domestic consumer context, or what type of legal principles you should be applying. So Oberman and Collins, the Deputy High Court judge, considered that a property portfolio which had been purchased by a couple during their 20-year cohabiting relationship could be the subject of a common intention constructive trust. And he held that that principle of a common intention constructive trust could apply to the fluctuating portfolio of properties, provided that you had all the hallmarks of a valid trust. So, you know, the requirements for making a trust and designating trust property were made out. The judge took the view that there was no rule that common intention constructive trusts only arise in a domestic context. What he decided and determined was that it was more difficult to establish such trusts in a commercial context, but there might be some sort of hybrid quasi-domestic case in which they might arise. I mean, I suppose...
Remind me, was this a purely commercial? There was no relationship between the parties at all?
No, they were in a relationship. They had been a couple for 20 years cohabiting together. But I suppose the point is, it's anyone's guess now as to whether the court views the purchase of the properties as almost a product of the relationship, and therefore common intention constructive trust applies, or whether it's incidental to, in which case it could be considered some sort of business venture, and therefore the resulting trust principle applies. I mean, if we look,
hasn't been overruled strictly.
No, indeed. No, indeed. And if we look at the next case, for example, next slide, Montalto and Poppet, I may not have pronounced that correctly, but this was an interesting case in which the property was held by the company, De La Croix Limited, as bare trustee. The parties had equal shares in that limited company. Next slide, please. And the contribution had been unequal towards the purchase price. The party that had made the unequal contributions effectively said, well, this is a resulting trust, and therefore I hold in proportion to the contributions that I had made towards the purchase price. The High Court held in this context that although the company was holding as bare trustee this type of property, it had effectively been a family home, and although the parties had rented the property out for a period of time, they had or were intending to use it as a family home after that. The court held that actually the resulting trust principle does not apply based upon contributions, but actually the presumption of equity following the law was the applicable analysis, and therefore, based upon the shareholding in the limited company, based upon the fact that those shares were held equally, that the presumption should be that the parties held the property, forgive me, as tenants in common, referable to the fact that they'd held the shareholding in the company that was holding the property on trust for both of them. So, I mean, the fact is that that's much more, I would say, akin to a commercial context. You've got a limited company, you're looking at the analyses of how the shareholding in the limited company is held, but actually the High Court viewed, well, let's have a look at the property, let's have a look at the intention for which the property was purchased, how it was owned, what it was used for, and irrespective of the fact that it had been rented out for a period of time, it was intended to be an asset of the relationship of the parties. So, I mean, you've got this tension. This is how I see these cases. You've got this tension between, Stacker Dowd and Jones and Connaught, Lascar, Marr and Colley, these most recent cases and fairly recent cases, which are saying, well, actually, let's look at the nature of the relationship. Let's look at the intention of the parties in co-owning. And let's really boil it down in that context. They're trying to offer, I would say, a gloss on the domestic consumer context by actually not simply pigeonholing a transaction into commercial, but looking at the nature of the relationship. And as I say, was the purchase a product of the relationship, or was it incidental to? That's my own view.
Yeah, I agree with that. I think the stress now has shifted. And what the court is more concerned about, rather than an arbitrary distinction between commercial, non-commercial, family, non-family, is on what was the intention of the parties at the time of the purchase. That's the bit that's driving the parties, because that's what Marr and Colley specifically says, is regardless of, let's not worry too much about rebuttal of presumptions, because the world doesn't really operate and cases aren't generally fought on what was the presumption. What it says is, what you've got to do is find what the intention of the parties is. And I think that's where this case is interesting, because it says, well, even though the ownership, the vehicle was a corporate vehicle, the intention was still as a family home. And it's that's the key objective as to how that should be then considered in terms of the behaviour of the parties and what agreement or otherwise was made in terms of co-ownership. So I think that's the central theme, and I agree entirely with you that it's all about now it's shifting towards intention rather than anything else.
And that, I suppose, is to ensure that the authorities are consistent with the approach of the very highest courts and obviously the Privy Council in terms of determining what amounts to a domestic consumer context and what amounts to a commercial type of context effectively. Well,
if you want to put a jurisprudential string to it, it's the only way you can actually thread these cases together, because otherwise they do stand in sort of stark opposites in some respects. But by concentrating on the intention, then it allows you to at least have a sense of consistency between them.
And I think you have to do that in trying to navigate and advise clients. I mean, one of the key points, what we would say is it's extremely difficult to advise clients based upon the case law that you're seeing, based upon the previous authorities, because it's anyone's guess really as to whether it's a commercial context or whether it's a domestic context. I think you really have to boil down to the nature of the relationship, as Paul says, the intention of the parties, and it's that will clarify as to the context that you find yourself in, I think.
And of course that, as the great lawyerly phrase always is, depends upon all the facts of the case, as every from the Supreme Court downwards is wont to remind us on a regular basis. So these are all fact sensitive, and it depends on how the judging question of your particular dispute is going to view these things. And sometimes that's, you get your crystal ball out and you hazard a guess, but it's not easy, as Eleanor says, as you say, that to sometimes divine quite how a court is going to view these things.
I agree. Next slide, please.
Of course.
Thank you. This case, I won't spend too long on it, Cape Horn and Harris. This was about at what stage does the court, or can the court, impute or infer or do whatever it needs to do as regards the shares that the parties have. Paul, next slide. Thank you. And the point is that the court isn't entitled to impute an intention to the parties at the first stage. At the first stage, what has to be determined is whether there is an actual agreement as to sharing ownership of the property, which may be express, so Lloyds Bank and Rossett, or inferred from conduct. And then at the second stage, the court is entitled to impute an intention that each party is entitled to the share which the court considers fair, having regard to the whole course of dealing. So that's your Oxley type argument, that's your Gissing and Gissing, that's your Eves and Eves, all of those types of arguments. But at the first stage, and it was a decision that was overturned on appeal, the judge had elided the agreement with the imputation, and the appeal court said, that the court is not entitled to do that at the first stage. All right, move on, please.
No, you want to just, this is an insult. I'll stand back at this because this is the realm of things I know nothing about. So
wearing my other hat, and I'll try not to tread upon the toes of our insolvency team, but I do quite a lot of insolvency and property crossover work. So this is a case, if there's anyone on from LCF, I'm sure they're more than familiar with it. It was a case that started out life, I think, in the County Court at Sunderland. I'll be corrected if that is not correct. But it's an interesting decision of His Honour Judge Kramer up in Newcastle, Pilmore and Mere, where if you're acting for a trustee in bankruptcy, this is entirely the case that you want to waive at and rely upon and put it front and centre in your skeleton argument, or indeed in any advice that you might give to the clients. It's about a wife who contended that she had a 50% beneficial interest in the matrimonial home. And on appeal, the point that was taken by the appeal court, His Honour Judge Kramer in particular, said, well, actually, what do you need to do in order to prove some form of beneficial ownership? And he took the view that Lloyds Bank and Rossett was still good law, that you had to prove either an express agreement or some sort of inferred agreement or implied agreement. And you had to have some form of reliance pursuant to that agreement. So you had to have either direct contributions towards the purchase price or direct contributions by way of mortgage installments, such as to create some sort of beneficial interest in the property. He also took the view, His Honour Judge Kramer, that there had to be some sort of exceptional circumstance that would give rise to a wife being able to demonstrate that she had a 50% beneficial interest in a property where she hadn't been on the title deeds. Now, having had a case that was going to come on for trial in front of him a few weeks back, that settled very much at the door of the court, he expressed at the PTR that there was this case in existence, which obviously he had determined. And I think there has been some criticism the judge had gone too far in his approach to Pilmore and Mia, that it had maybe been a little bit unfair on a wife who had obviously not played a major role in the financial affairs of either the business or the home. And there were cultural significances and cultural impacts as to why she might not have been on the title deeds. But it's there, look, it's an authority that assists the trustee in bankruptcy if the trustee is seeking to realise that the matrimonial home and seeking to effect an order for possession and sale. And one of the points that we wanted to consider as part of today's seminar is, orders for sale and trusts of land don't simply crop up in the context of cohabitees or anything of failed relationships. Quite often crops up in the context of section 335A3 of the Insolvency Act 1986, which is, I'm sure, more than familiar to people who act in the insolvency sphere, where a trustee is seeking to realise bankrupt's property for the benefit of the bankruptcy estate. And in circumstances where someone contends that there is a beneficial interest in the trust property, and in the matrimonial home, for example, which is the most common context, section 14 of Talata comes into bearing, albeit that the circumstances and the relevant factors are determined in accordance with section 335A of the Insolvency Act. And normally, if a trustee seeks to realise a matrimonial home or trust property more than 1 year after the first vesting in the trustee, then the presumption applies that's set out in that section of the Insolvency Act.
Eleanor, can I just jump in? The classic definition, I think, as still set out in things like Snell's Equity and Lewin on Trust for common intention constructive trust, is that you have an agreement and then you have detrimental reliance. It's basically the same formulation as a proprietary estoppel. To what extent did Fillmore, and it's still, to a large part, it's an area that's not really touched upon in Stack and Dowd and Jones and Knott. So does Fillmore and Mike give us any guidance as to the extent that detrimental reliance is still a necessary part of common intention constructive trust?
Not really. It doesn't, I think, deal with that particularly well. I still take the view, and we spoke about this earlier, that if you're advising clients, you advise them that they need to prove detrimental reliance if they're seeking to rely upon a common intention constructive trust, and to make the point that there needs to be evidence that XYZ was done in reliance upon the agreement, and that reliance was to a party's detriment.
So it's still the Lloyds Bank and Rossett formulation, isn't it, to that extent?
Yeah.
You need to have done something, you've got to pay something, you've got to do something. They're not quite so keen on building patios as they once were, but you still have to have contributed in some way to it.
Exactly. And what Pilmore and Mia does make clear, actually, is that if you don't have the evidence to back up your case, so if, for example, you maybe get home on some express discussions, but that there isn't evidence of financial contribution, then it's not right for the court to try and tease out of the parties, to try and get that evidence out to cross the line. It's actually for the court to say, well, no, you have not rebutted the presumption. So in sole ownership cases, presumption is that equity follows the law. If you can't rebut that presumption, your claim to a half share fails. And Pilmore makes that clear, makes the point that if you can't tick all the boxes in terms of what you need to prove, your claim to a half share fails because you need to make all the running to rebut the presumption.
Does it deal with the argument that's usually run in those kind of situations where the mortgage is paid all by one person, but normally the person who doesn't pay anything to the mortgage runs the argument of, well, I paid all these bills, so therefore that allowed my partner to pay the mortgage, which he wouldn't have been able to do if I hadn't paid all these bills. So I'm contributing to the household expenses generally. Is that enough to get you over the evidential burden? Was that dealt with at all?
That wasn't really dealt with because on the facts it didn't work, but I've certainly had that as part of another case where the wife effectively ran the argument and said, well, my contributions were by way of paying the household expenses in their entirety. That freed up capital to enable my husband to pay the mortgage, for example. And the judge seemed to accept that. It's all a case, really, as you've said, as regards our other co-ownership cases. They all turn on the facts.
All on the facts.
So I think Pilmore is a very useful case if you're acting for a trustee in bankruptcy, seeking to say, well, actually, this is what needs to be proven in order to get a claim to a 50% beneficial interest across the line. And I'm sure all of us know cases where they're almost always pursued. And they're almost always pursued not necessarily on the right factual basis. For example, you might expect there to be a pleading of an express agreement, and it never happens. And then you get to trial, and all of a sudden, scales and argument crops up from the other side that says this is a case in reliance upon express agreement. You're like, okay.
I had that precisely the other day. Their pleading consisted of this happened, then this happened, so therefore it was held as tenants in common. But by the time we actually got to submission, suddenly it turned into, no, this was an implied express agreement case. And it's like, well, this is never pleaded.
I'm conscious that we only have 8 minutes to go. And
before I start on a rant on pleading.
No, it's okay. What I'm going to do is to just talk about some headline points on the Insolvency Act, and effectively the point at which Paul jumped in. I think I was talking about the 1-year presumption. So the presumption is that if a trustee applies for an order for possession and sale more than 1 year after the vesting, then the interests of creditors are deemed to be paramount to outweigh all other considerations, unless there are exceptional circumstances. And what I've got on to consider is what effectively amounts to exceptional circumstances. The mere incidence of insolvency and the mere incidence that a family might be made homeless effectively, or that the wife and children might have to vacate as a result of a bankruptcy order and an order for possession and sale being made, is not considered exceptional circumstances. There's a case of Reed Chitro, Dean and Stout makes these points. So the mere incidence of insolvency isn't enough for the court in those circumstances to refuse to make an order for sale. That in and of itself is probably a whole other topic that we could explore another day. So I'm not going to get into that too much, but safe to say that these same types of arguments as to beneficial ownership, same types of arguments as to co-ownership of property, apply in the context of insolvency law as well. And it's exactly the same guiding principles that are relied upon Stack and Dowd and all of those other cases. So
if anyone needs to know, you're the person to come and ask. That's the headline.
Or the insolvency team per se. All right, let's talk about procedure, Paul, and let's talk about sections 14 and 15.
Yeah.
Do you take the view that Part 8 or Part 7 should be used normally?
Well, I hate Part 8 just as a general passion, generally, because I find it utterly hopeless as a mechanism for starting proceedings or getting to trial and understanding what it is people are actually arguing about. So my preference is always to start things by Part 7. And I've never known a Talata claim yet that doesn't have a substantial dispute of fact. So my general rule of thumb would simply be to issue it as a Part 7. I mean, I've just issued fairly recently an £9 million Talata claim that arises out of a farm partnership, where strictly speaking, everyone on the face of it, there's an express declaration of trust for the partnership. It's tenants in common and equal shares. But I know that the brothers can't agree on anything. They can't agree what day it is. So there's likely to be a huge dispute as to what it means. So I put at the bottom where we started this at Part 7 because we think there's going to be a significant dispute of fact. But if there isn't, we're quite content for it to go as a Part 8. And that's how I deal with it.
I suppose the thing is the pre-action correspondence will flush out, won't it, whether there are likely to be substantial disputes of fact, which may render it inappropriate for it to be heard on a Part 8. Superficially, of course, if you're looking at that type of Goodman and Gallant scenario, where you have an express declaration of trust in the box 10 that has been ticked, you might say, well, that would lend itself to being issued as a Part 8 claim.
That's the only kind of claim I can see where you might. Yeah.
And I think if it's clear that there isn't going to be any mounted challenge to that express declaration of trust, then it seems to me if you're simply arguing about whether the property should be sold or not, pursuant to sections 14 and 15 of Talata, then you could probably proceed down the Part 8 route with some certainty. I think the point is if there's going to be, and you know that there's going to be issues raised, both factual and legal, you embark on the Part 7 as I see it.
But the minute you get into trawling through any kind of, the whole course of correspondence between the parties. Because I have had judges who said, well, the whole correspondence of dealing with the property, I've got to take into not just their dealing with this property, but the other property that was sold, and the proceeds got rolled into this one. So you end up with trawling over, it can be 20, 30 years of property ownership. And I've never known two parties agree precisely what happened at any particular day or what their intention was. Certainly not when it comes to agreeing what or the impact that may have on potentially their share of the equity of the property. So
we all know that in seeking an order for sale under section 14, the court must have regard to the list of factors in section 15. So that's this slide, and deals with part of the consideration as to what orders the court can or can't make. So for example, I'm sure many of you have come across the case of Begum and Hafiz and High. I'm always asked this question, and this is the case I always go to, does the court have power to order the sale of one beneficial interest to another co-owner? Well, no, it doesn't have that power, and that's the case that Begum makes that clear. What it can do is
it makes it clear, but then it sort of does it, which is always interesting.
It can basically say, well, actually, there should be a period for a co-owner to bid or buy out the other co-owner's share.
It granted an option, basically, didn't it? It granted an option. It could buy it. You've got 3 months to buy out at this price, and if you do that, then fair enough. Otherwise, it goes on the market. Yeah,
exactly. But there's no power to compel someone to sell their interest to a co-owner. That just doesn't work.
Either way around, you can't compel one person to sell it to you, and you can't compel the other person to sell.
Agreed.
It works. It's both ways. It works or doesn't work, should I say?
So where are we at currently? How do we think that things are going to go, subject to any questions that people may have? We're not doing badly on time. I think there is a real risk, given how difficult the last year has been for everyone, that unfortunately there's going to be increased relationship breakdown, and couples who are unmarried may well split up. People will be worried about financial repercussions, bankruptcy potentially, and concerns about ownership as to the matrimonial home will, I'm sure, continue to be paramount. What can we do to address that, really? Well, I suppose one of the points is, if you're not on the title deeds, sit your partner down and have a discussion. And if you're a lawyer advising people, impress upon them that the fact that this area is very difficult, and should, for example, a bankruptcy order be made, then it's likely that the trustee will come after the matrimonial home if there's equity in it above £1,000.
Yeah, so you can get a memorandum that complies with section 53, because a memorandum, of course, it doesn't have to be made at the time of the declaration of the trust. A memorandum is just a memorandum. It just has to be recorded in writing that there was a declaration of trust at some point, and that's good enough for section 53. It's not the memorandum itself that declares the trust. The trust is declared orally, and it's the memorandum that simply records the declaration of trust.
I also think that we're going to have many more arguments about this commercial domestic consumer context. Paul, you said you had it a couple of weeks ago, this point about, well, actually, which is the applicable law? Does the resulting trust apply? Does it survive in this context? Is it a common intention constructor trust? How should the court apply the law to situations where assets have been owned jointly? Is it an investment? Is it a business type context? Or is it actually the intention of the parties was to share the assets across the relationship and across the duration of the period that they were in a relationship with one another? So
yeah, on that point, I do genuinely think that the courts are moving away from a reliance on presumptions. Presumptions, of course, only exist for the benefit of parties in the absence of evidence. The courts don't like deciding things on presumptions, and so what they are, they're moving away from assuming that the presumption of resulting trusts works in this scenario and it doesn't in this, and as to looking at, well, what were the intention of the parties, and attempting, whether that's by way of resulting trusts still or Stack and Dowden type analysis, to give effect to the intention of the parties. Most courts, you've got to remember, are merits-based courts. So if they think your client has merit and it was intended that they should have a share, no matter how vehemently it's denied later by one party or the other, then that's what the court's going to tend to do. So I think drilling down into intention, and intention at any specific time, because we know that it can vary, and if there's a proper shift, and you've got evidence of discussions that, well, this is the basis we bought it, but now, you might have kids at this point, so it changes. There might be a change in relationships. Kids might leave home, so there's a difference.
Someone might lose their job, which would be very unfortunate, but it would impact upon who was presumably paying the mortgage, who was paying the lion's share of the household expenses. Oh, we have a question. So I think all of those types of discussions are extremely important for advising clients properly, which I think is going to be very prevalent types of advice in the current climate, really.
Yes, and Lauren Partridge is right in that, more and more, I'm beaming from my front room. So more and more we're working from home. So does that make whatever trust I hold this on with my wife, is this a commercial enterprise? Should we be considering resulting trusts rather than what our intention is? Or
that's a super point. I think that's such a great point. And I think that observation just shows how difficult it will be to advise clients with any certainty, because we all know that clients want a definitive answer. They appreciate that there's risk, but they still want you to commit and say, well, actually, notwithstanding that there's risk, I think on balance, the court is likely to find as follows. And I think where we are is that we're in fairly uncharted waters, given everything that's happened over the last year. And I think it will be interesting to see, will there be cases that will come out of the last 12 months that determine this point based upon people working from home or people using their home as the home office effectively? So that's a super point. Thank you for that.
I'm conscious that it's now 5:05. So I propose, Eleanor, unless you've got anything you bursting to say that needs to be imparted, to draw this to a close and to thank everyone for coming. Is there anything else you want to say in?
Not unless there are any other queries or any other raising of hands. If not, then thank you all for your time. We appreciate your attendance very much. Hope you found today helpful. I hope you found it informative. And obviously, if you've got any questions after today, please do get in touch with either of us and we'd be more than happy to answer any questions, wouldn't we, Paul?
Oh, yeah, I can't stress that point enough. If there's anything that you want to ask that doesn't really function very well in the chat, just get in touch with Chambers or with Eleanor or myself directly, and we'll happily answer any question. One of the good things about Kings is we're a friendly bunch. We don't bite often, and we're very approachable. So by all means, get in touch and we'll do what we can.
Oh, do we have another question?
We do. Do you recommend that solicitors draft claim forms or particulars of claim? Claim forms, I've got no objection. Particulars of claim, my view would be that it's best, particulars of claim are best drafted by barristers, but people may say I have a vested interest in that.
I suppose the thing is, the view I take, absolutely, the solicitor is well adept at drafting the claim form. I suppose if it were me, I'd want the person who will ultimately be presenting the case at trial to have settled the pleadings, be that the particulars of claim or be it the defence. So if you're going to ultimately be trial counsel, I suspect you need, an early conference with the client to try and thrash out all of these points. You would then settle the pleading for whichever side that you would be, and then you would hopefully be the counsel that ends up at trial. I just think that consistency in terms of presentation means so much, really.
And on a more serious note as well, it's the advantage, which again, having been a solicitor, I understand the advantage of the bar, perhaps more than those barristers just constantly been at the bar. It's that independent look that you get with a barrister looking at the papers and having that initial discussion to understand what the case is, that sometimes you can lose just simply by doing it as a solicitor yourself, because again, it's just a simple wood for the trees. Having that independent extra pair of eyes go over things and say, yes, this works, but hang on, what about this point? We're a bit light on this, what happened to this evidence? So I think involving the bar is useful from that point of view, having, as I say, having been on both sides of the fence personally. So on that point, I will say good night from me, and
good night from me.
Good night from him. And Oh, I've got to say as well, this is part of an ongoing series. So there's going to be a number of people from the property team giving chats or talks, some more or less formal than others. And they're going to happen about every month. So keep an eye out for those. And please let us know if there's anything in particular that you want us to talk about. We're more than happy to adapt these to topics that you really want to hear about. Because let's face it, there's no point telling you stuff that you're not interested in.
No, indeed. Thank you, Paul. Thank you for your time.
Thank you, Eleanor. Pleasure.
All right. Take care, everyone. Bye.
Thank you very much.
Thanks, Paul. Bye now.